He replied, "What do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. Exclusive political jurisdiction. That's what it means." He further stated, "Subject to the jurisdiction thereof" means subject to the complete jurisdiction thereof. Any divided loyalty meant no citizenship, just as it did in the preceding Civil Rights Act of 1866. The question is, does anybody born on American soil instantly become an American citizen for simply having been born on American soil, or is more required? And is the more that's required something that would prevent someone born to, say, green card parents not qualify for birthright citizenship? Would it mean that someone born on American soil to transient visitors, sojourners, people on a work permit, a student work visa, student visa, travel visa, their children born on American soil would not be American citizens? Does it mean people born to illegal migrant third world invaders of our nation on American soil do not qualify for automatic American citizenship? Or is the proper understanding of the 14th Amendment that only persons born on American soil to American citizen parents qualify for automatic birthright citizenship? Unfortunately, we have some incorrect Supreme Court precedent that suggests that also applies to green card holders, permanent resident aliens. There's actually no American law that holds that transient visitors, children born on American soil, or invader children born on American soil are automatically American citizens. But of course, those are two of the Democrats' largest political constituencies at this point. So they are fighting desperately to make sure that no matter, even if you're an unlawful invader of our nation, if you pop out a child, that child becomes an anchor baby. That's the colloquial phrase, right? So let's jump into this court brief. This is a brief. A brief is an argument that's filed before a court. This one's filed before the Supreme Court, which is scheduled to hear argument on the merit for birthright citizenship in the context of Trump's executive order on birthright citizenship. A brief of 18 members of the Committee on the Judiciary of the House of Representatives as amici curiae. The amici are 18 members of Congress who serve on the Committee on the Judiciary of the House of Representatives. Jim Jordan, Andy Biggs, Chip Roy, Brandon Gale. I won't read all of them, but these are big names on the Republican side of the aisle. They have a strong interest in the outcome of this case because Congress, as a co-equal branch of government, has an interest in the courts upholding the Constitution, of course. An alien who seeks political rights as a member of this nation, as a citizen, can rightfully obtain them only upon terms and conditions specified by Congress, either in an amendment or in a statute. Because of the lower court's decisions that contradict this well-established rule, this court, the Supreme Court, should grant the petitions. To clarify what actual birthright citizenship is, the 14th Amendment confers citizenship on any person who is both born in the United States and subject to the jurisdiction thereof. The first clause has been construed to exclude those born in U.S. territories, despite being literally in the United States. And jurisdiction in the second clause, the jurisdiction clause, invokes the historic doctrine of ligentia, meaning the person must owe direct and exclusive allegiance to the sovereign, which in turn must consent to the person's presence. So these are two important points. By the way, the men who ratified and wrote and ratified the 14th Amendment did not use this term in their debates. I know because I've read their debates. But this is the argument they were making, that by subject to the jurisdiction they did use the word exclusive, the exclusive political jurisdiction thereof. That's one key point. The second key point is this one, that the sovereign, America, must consent to their presence. So the children of illegals clearly would not apply as qualified for birthright citizenship. Notably, the jurisdiction clause does not say the person must be subject to the laws of the United States, which would be like criminal jurisdiction, mere criminal jurisdiction, but rather subject to its jurisdiction. The distinction matters. Even in modern case law and statutes, jurisdiction is a word of many, too many meanings, so it should come as no surprise that the meaning of that term in an amendment written nearly 160 years ago would be nuanced and invoke pre-existing doctrines. As the D.C. Circuit has held, birthright citizenship does not merely follow the flag. The evident meaning of the word subject to the jurisdiction thereof is not merely subject in some respect or some degree to the jurisdiction of the U.S., but completely subject to their political jurisdiction and owing them direct and immediate allegiance. And this is a major Supreme Court case from 1884 on this question of birthright citizenship, Elk v. Wilkins. There is widespread agreement that the jurisdiction clause means that children born in the United States to ambassadors or invading soldiers would not receive citizenship under the 14th Amendment. The best reason is because they do not owe total allegiance to the U.S., rather than, as the plaintiffs for broad birthright citizenship contend, rather than because those groups allegedly have immunity from federal law. Well, I mean, an invading soldier would clearly not have immunity from federal law. There is a wealth of support for the proposition that the jurisdiction clause applies the same to children of those illegally present because they, like ambassadors and foreign soldiers, do not owe total allegiance to the U.S. They remain citizens of their home countries to whom they owe at least divided allegiance, and which often imposes birthright citizenship of its own on the children born to its nationals in the United States. Allegiance is also a reciprocal relationship. This is super important, folks. It's a two-way relationship. Not only do you want to be a citizen, but America wishes for you to be a citizen. It's a marriage of sorts. The person must be present with the consent of the sovereign, a factor on which the court extensively relied in United States v. Wong Kim Ark. So Wong Kim Ark is the case of the child born to Chinese nationals who were permanent resident aliens in the U.S. It's because they were permanent resident aliens, they were present with the consent of the United States, that the Supreme Court found that their child, although born to Chinese nationals, they never changed their citizenship, born on American soil to Chinese nationals, was nevertheless an American citizen because they were all present with the consent of the United States. But illegal aliens and their children are present in the United States without consent. Early English case law supports this concept of total sovereign allegiance and its role in citizenship, even the senators who drafted and debated the jurisdiction clause stated that the children of aliens or others owing allegiance to anybody else would not receive citizenship. That understanding extended for decades after the ratification of the 14th Amendment. And some modern scholars argue that the core purpose of the citizenship clause was to include in the grant of birthright citizenship all who are lawfully in the United States. And scholars have also distinguished the case law on which the plaintiffs, the people who want universal birthright citizenship, rely. Because the 14th Amendment does not confer citizenship on the children of illegally present aliens, and because Congress has not done so by statute, which it could do, by the way, the other branches cannot confer such citizenship on their own. Citizenship can only come from Congress. The Trump executive order at issue here properly ensures that the rule, the actual correct rule, is followed within the executive branch. But the lower courts, the unelected black-robed tyrannical inferior district trial courts, nonetheless enjoined the executive order. This Supreme Court should grant review. And they look at English law, not because it's controlling in America, but because it provides insight to how our founding fathers and our senators in the antebellum period would have understood the law. In Calvin's case, which this Supreme Court later cited in Wong Kim Ark, Lord Coke, a famous English jurist back in the day, Lord Coke explained what made someone subject to the jurisdiction of the English courts. He quoted that, oh my gosh, they have a bunch of Latin in here. He noted that it is not climate or soil that makes someone subject to the authority of the jurisdiction, the sovereignty of the state, but allegiance and obedience that make one subject to the laws of the country. Jurisdiction, in that sense, does not turn simply on whether the person was present within the territory or subject to its laws, but whether he owed allegiance to the sovereign. As the D.C. Circuit has explained, Calvin's case means those born within the king's domain and within the obedience or allegiance of the king, were subjects of the king or citizens in modern parlance. And I would just note, by the way, that this is also a two-way relationship, even in Old English law. So you would, if you got the benefit of English citizenship, you got the protection of the crown and all that cool stuff. You were also obligated to pay taxes. You were obligated to serve in the military. The government had claims upon you because you were a citizen. Lord Coke cited several prior cases to make the point. Most notably was Perkin Warbeck's case, where a Dutchman declared himself the rightful heir to the English throne, traveled to England in an attempt to take the throne. He was captured, but the English court concluded he could not be punished by the common law because he was not subject to the civil court's jurisdiction. There was no state of war between the countries, but his mere presence was unlawful, and so he had never been under the protection of the king nor ever owed any manner of allegiance to him. As Professor Eyestreicher explains, Warbeck's very setting foot on English soil as a pretender to the throne made him a criminal in the eyes of the English law, one who had never claimed the protection of the king by virtue of his lawful presence in the realm. Thus, it was the illegality of Warbeck's presence that placed him outside of the ordinary jurisdiction of English law. By the way, in this morning's show, someone had asked me, why do aliens, especially illegal aliens, get constitutional rights in America? And this is really touching on the same issue, right? You get rights when you're recognized by the state as being lawfully present in these cases. America could make the same determination. They could say, hey, you get like due process, you get a jury of your peers, you have a right to counsel, all this kind of stuff, Miranda rights. You get that if you're an American citizen, but we don't have to give that to you if you're an illegal migrant because you're not a recognized part of our American body politic or even a lawful visitor. Understanding of citizenship during the drafting of the 14th Amendment. The concept that jurisdiction included two aspects: being subject to a nation's laws, like criminal jurisdiction, but also holding allegiance to the sovereign, political jurisdiction, continued into the international relations and American practice in the lead up to the 14th Amendment. The status of dual allegiance, ordinary as it seems today, seems anomalous and inappropriate in the 1860s, as the general view was that no one can have two countries. So dual citizenship has become common in modern times. Should America recognize dual citizenship? Should it be allowed? I've mentioned before, I've had the opportunity to pursue dual citizenship, but I've always been concerned that in claiming citizenship in another country, I could be waiving citizenship in America. And American citizenship is all important to me, so I've never pursued that possible second citizenship. Lots of people have dual citizenship today because we allow it, but should we allow it? Or should we demand that everyone who claims American citizenship is exclusively loyal to the sovereignty of the United States? Continuing now, at the time of the 14th Amendment's drafting and ratification, the term immigration status would have been meaningless because the U.S. had only minimal immigration laws in the modern sense, and instead the crucial inquiry was the parent's allegiance to a foreign country. That's because the general rule at the time was that citizenship of a child followed the parent's citizenship. The child inherited the citizenship of the parents, and their original sovereign would often claim the allegiance of the child regardless of where he was born, as British law at the time plainly did. Again, remember, if you were a British citizen, the crown had claims on you, almost like a property interest. They did not want to give that up. So if you were born to British parents anywhere in the world, the British would say, yeah, you owe us. You're a British citizen who owes us fealty, military service, taxes, all of that stuff. U.S. law was the same. In 1855, Congress enacted a law dictating that persons heretofore born or after born out of the limits and jurisdiction of the United States, whose fathers were or shall be at the time of their birth citizens of the U.S., shall be deemed and considered citizens of the U.S., except for persons whose fathers never resided in the U.S. Accordingly, in 1866, a foreigner could be domiciled in the U.S. but remain subject to a foreign power. With this background, the terminology used by the drafters of the Jurisdiction Clause makes more sense to modern readers. The history of the Jurisdiction Clause begins with the Civil Rights Act of 1866. This was the statute I mentioned that essentially had the birthright citizenship language of the 14th Amendment clause in statute form. It read, all persons subject in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the U.S. Senator John Bingham, a principal author of the future 14th Amendment, said this provision meant that every human being born within the jurisdiction of the United States of parents not owing allegiance to any foreign government would be a citizen. This invoked the concept of total allegiance to the U.S., a concept defeated if the parents, and thus their child, owed any allegiance to their home country. There were, however, serious doubts about whether Congress had constitutional authority to enact that statute. President Johnson vetoed it, in part on that basis, but the veto was overridden, and so it was clear to many in the Republican majority that a constitutional amendment would be needed to give the Civil Rights Act a solid foundation on which to survive future legal challenges. Accordingly, it cannot be seriously doubted that what would become the jurisdiction clause of the 14th Amendment was intended to have the exact same meaning as that earlier statute, which referenced foreign allegiance. The earliest draft of the 14th Amendment originally included no citizenship clause, but in May 1866, Senator Wade sought to replace the word citizen in the Privileges or Immunities Clause with the phrase persons born in the U.S. or naturalized by the laws thereof. This prompted a discussion of whether that was actually the proper definition of a citizen, simply being born in the U.S. Senator Jacob Howard, a sponsor of the 14th Amendment, soon proposed a new clause, the Jurisdiction Clause. All persons born in the U.S. and subject to the jurisdiction thereof are citizens of the United States and the states wherein they reside. Importantly, Senator Howard explained that this will not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of persons. This express reference to aliens suggests that even the drafter did not believe it would apply only narrowly to children of ambassadors who are listed separately. In other words, the exclusion. The primary focus of debate during this time was whether the jurisdiction clause would extend to Native American Indians, who were not expressly mentioned in the clause. Senator Edgar Cohen noted that it is perfectly clear that the mere fact that a man is born in the country has not entitled him to the right to exercise political power as a citizen. Sojourners or travelers, for example, have a right to the protection of the laws, the criminal jurisdiction, but he's not a citizen in the ordinary acceptance of the word. The right to protection of the laws invoked a narrower sense of jurisdiction, political jurisdiction. The narrower sense, protection of the laws was criminal jurisdiction. But to become a citizen, something more was required, political jurisdiction. Senator Lyman Trumbull, chair of the Senate Judiciary Committee, seen as the Senate expert on the closely aligned Civil Rights Act of 1866, was asked what the jurisdiction clause meant. He replied, "What do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. Exclusive political jurisdiction. That's what it means." He further stated, subject to the jurisdiction thereof means subject to the complete jurisdiction thereof. Any divided loyalty meant no citizenship, just as it did in the preceding Civil Rights Act of 1866. Applying that test to Native American Indians was seen as so straightforward that the drafters decided against including an express exception for Indians not taxed, as they had done in the earlier statute, and would also do in Section 2 of the 14th Amendment. Federal law had long applied to Indians, like the criminal law, but they owed at least partial loyalty to their tribes, and so the jurisdiction clause unambiguously meant the 14th Amendment would not confer citizenship on their children. Again, it took that 1924 statute by Congress for Native Americans to have birthright citizenship simply by being born on American soil. Congress later granted Native American Indian citizenship via statute. That's a statute. But until that time, the Indians were regarded as alien people residing in the U.S. and thus were not born in the U.S. and subject to the jurisdiction thereof within the meaning of the 14th Amendment. As modern scholars have recognized, Senator Trumbull and those who agreed with him spoke of the jurisdiction arising from allegiance, not mere presence. Everyone recognized a narrow form of jurisdiction, meaning entitlement to protection of the laws, but it's clear that the men who drafted and passed the Citizenship Clause recognized a second degree of subjection to a country's jurisdiction, a subjection to its complete jurisdiction in ways more closely associated with the rights, duties, and deeply rooted natural allegiance inherent to long-term residence in and meaningful interaction with a particular society. My people. And that more complete form of jurisdiction was needed for citizenship. Merely being born in the U.S. and being subject to its laws was insufficient. If the parents or child had divided allegiances, the child would not be a U.S. citizen under the jurisdiction clause of the 14th Amendment. That approach directly tracked the Civil Rights Act of 1866, which the jurisdiction clause constitutionalized as an amendment. Recall the act excluded those who owe allegiance to any foreign sovereignty. That same limitation was carried into the jurisdiction clause, except the latter was stated affirmatively with regard to the United States, whereas the act had been stated negatively vis-a-vis foreign sovereigns. But they mean the same things. As noted, the most common example at the time of someone who lacked complete allegiance to the U.S. would be the children of Indians. But the same rationale that excluded the children of Indians would exclude the children of Europeans born in the United States if the European power involved claimed the allegiance of the child, which, most notably, British law at the time plainly did. But because no one could owe allegiance to two sovereigns at the same time, such children could not claim total allegiance to the U.S. and thus would not be citizens under the 14th Amendment.